A very good afternoon to you all and a warm welcome to this edition of the Citizens Chat Show, streaming on YouTube at Civic Space TV. My name is Judith Atim, I'm your host, and welcome once again. Today we are talking about the challenges of implementing the recent Supreme Court ruling on the trial of civilians in military courts. And I'm pleased to be joined by my guests, Dr. Robert Ojambo from my immediate left, who is the head of the History Department at Kyambogo University. Good afternoon, Dr. Ojambo.
Good afternoon, I'm glad to be here.
Thank you very much. Next to Dr. Ojambo is Dr. Sarah Bireete, Executive Director, Center for Constitutional Governance. Good afternoon, Dr. Sarah.
Thank you. Good afternoon, viewers.
Good to have you. And next to Dr. Sarah is, of course, our guest making his first appearance, the Honourable George Odongo, who is the NRM MP at the East African Legislative Assembly. Honourable, a pleasure to have you on the show.
Thank you very much. I'm not an NRM MP.
Yeah.
I am
Ugandan MP.
Honourable
Yes.
George Odongo, Member of Parliament at the East African Legislative Assembly.
Yes.
Yes.
Thank you so much.
And next to him, of course, is Mr. Joseph Ochieno, who is a political commentator and the UPC Ideologue. Joseph, always a pleasure to have you on the show.
Thank you for having me. I'm delighted to be here, and I'm flanked by a member of the East African Legislative Assembly, and we shall be discussing the future of this continent beyond, beyond the Supreme Court ruling.
All right, thank you very much. So, well, as you know, the recent landmark Supreme Court ruling, which declared the trial of civilians in military courts unconstitutional, got a lot of Ugandans excited, including here on this show when we last had this discussion. But like many of you, like it is said in most times, the path to justice is never without challenges. A day after the ruling, President Yoweri Museveni issued a statement via his X handle describing the ruling as the wrong decision by the Supreme Court in the matter of the armed civilians being tried by the military court-martial. He went on to justify the trial of civilians in the military courts as a method which his government has used to reinforce the civilian judicial system to defend people's lives against criminals armed with guns. But hours before the president's statement, a high-ranking serving UPDF officer, Colonel Chris Magezi, who is the military assistant to the CDF in charge of public relations, posted on his X handle a comment which was quite alarming and purporting it to be the official position of the UPDF on the Supreme Court. It read, "The General Court Martial will continue to try anyone who conspires to murder the president, commits armed rebellion against Uganda, and engages in terrorism against the people of Uganda. Under no circumstances will Colonel Kizza Besigye be released until he faces the full extent of martial law." He went on to say, "The final decision on this matter will be taken by the Commander-in-Chief and Chairman of the High Command, General Yoweri Kaguta Museveni." Now, in today's edition of the show, we delve into the complexities of this ruling, and we shall be exploring the legal battles, the human rights concerns, and importantly, the potential implications for Uganda's justice system. My guests are here to unravel these challenges of implementing this groundbreaking ruling by the Supreme Court. And my first question to you all regarding this ruling is, in light of the developments we've seen, the comments by the president, the comments by officials in the UPDF, what does the journey ahead look like for us as a country? And was the celebration a little too early? I'll start with you.
Yeah, thank you so much, Judith. You know, to describe to you how I felt when that ruling was made, I'll just tell you a brief story that was told to us by Professor Ali Mazuri. He told us a story that he was living at Makerere Flats. So he woke up one morning and he picks a newspaper that they used to slide newspapers inside their doors. So when he read, they had pushed something. So he read Ken dead. Ken dead. So he did not know which Ken is this. The first Ken that came in his mind was Kenyatta, because he was a Kenyan. Thought it was Kenyatta. But when he pulled the newspaper, he found out that it was J.F. Kennedy. And he said he was shocked but relieved. So that is the experience I had also. I was shocked by the ruling, but at the same time relieved.
Pleasantly shocked?
Yes. Why was I shocked? I didn't expect in 2025 a Supreme Court in Uganda to come up with that type of judgment. 360 pages of very elaborate and talking about our history, pointing issue by issue, in fact exploring even issues which were not before them. But they delved into them and they gave answers. And then finally, they gave orders and they gave, how do they call them, Sarah? There are two types of orders. The absolute orders and the advisory orders in the same judgment. And they were very, very clear. So I was really shocked. And I had to even look at the photo of a Wingdall and say, is he the one? I was really shocked that he was the one. He was meticulous. The judges, Elizabeth Msoke, and the others, the justices, they were meticulous. Those ladies, if only court would keep like that for the next 5 years, the judiciary of Uganda would be a benchmark for many African countries. But I was relieved also that for the first time this Hydra, almost something that had perturbed everybody, something that had beaten common sense, because what they were deciding on was really a matter that common sense would really say so. Because if you say that this is a court martial, then how do you gonna make it a court that tries everybody? And they would tell me that, you know, if you behave like a soldier, and I would ask people, I've asked on this show, that if I sleep in a garage, do I become a car? Or if, for example, I put on something for Muslims, do I become a Muslim? There are proper ways of somebody becoming a soldier. You must enroll, you must be on duty, you must be given a number, you must be commissioned, and many, many things. So how do you mistake a soldier with any other person? The other day I was seeing Nalueiso, General Nalueiso, and I saw, maybe it is an effect of age. She was saying, Besije is a soldier. I said, but the general. You know, generals, like for us who come from university, are professors of the military. So if you're a general, you have gone through a lot of training and experience. You know things. I was asking, if somebody retires, does he still remain in that function? And one of the judgments by one of the lady justices was the key to me. She said that even a soldier who has gone AWOL or who is not on duty should not be tried in the court martial, because he has committed that offense when he's in the civilian life there. He's not on line of duty. Going back to your question, the biggest problem in this country is that we have not understood our politics. And for me, I am not shocked of what is happening, because I have been reading Ugandan history for all my life. And therefore, I know how our presidents behave. I know how our government behaves. I know how our institutions behave. For example, leaders in Uganda pretend that they know everything. In other countries, presidents are advised on everything that they do. Because when you're a president, you are not knowledgeable in everything. You have just been given an opportunity to lead. And unfortunately, we learn that. If we don't learn that, we're going to have problems. Here in Uganda, you have a president who knows everything. He says, they are wrong. This is a mistake. And people believe in him. In fact, when I was coming on radio, I was hearing the RDC of Mukono quarreling that how can the president give you money and you vote, you give him only 4 votes? And I was asking this RDC, is that money for the president? So for me, we are only shocked because We don't know how the government operates. Sometimes the president of Uganda or the government, in most cases, works on reverse psychology. They do something, but they don't mean what they are doing. So when this ruling came out, people jubilated. But I kept reading. Me, I'm not a lawyer. I was just reading like a lay reader. And I said that there are certain things that Justice Owinyo would have been very clear. You are saying that the cases at the court martial should cease. Then, when they cease, why don't they stop there and those people are released? Because I find it very difficult, as you are saying, a challenge. Now, in which jurisdiction do we take these things? First of all, court martial issues are not DPP's matter. Now they are telling us the DPP is still seeing the files. So there was some little ambiguity that needed to be corrected. However much I've praised the judgment having been very correct, but there were some little ambiguities. And they said the other files of criminal offenses that are still before the court martial should be transferred to the civilian courts or the courts of judicature. But still I was wondering, if something has already started been doing badly, how do you, because a charge was made there, the criminal case was made in that bad court. Now how do you take it to these other courts? So those are some of the challenges, but we shall hear what the lawyers are saying.
Thank you.
But for me, I want to tell you that I think, and yesterday I saw Professor Mbazira of Makerere University saying that they have started using this judgment as a case law. Something that they are using in class to teach the students, but it is going to be good for some of us to write history out of this.
Thank you very much, Dr. Ojambo. Dr. Sarah, let me come to you. Did we celebrate too early as a country, and what does the journey ahead look like?
Well, I don't think we celebrated too early. And I want to invite Ugandans to continue celebrating the ruling, continue celebrating the judgment. Those who are lamenting about this resounding judgment are like people watching a horror movie because of their bad faith. They are watching a horror movie, so it's okay to cry when you are watching a horror movie, to release emotions. Let them lament. This is an apex court. There is nowhere to run. Supreme Court decisions are precedents. They are as good as law. So that's why the professor was saying they will teach it to students. So let them, those who are lamenting, let them lament. There's nothing to do. There's nothing to do about it. They are not happy because the military courts were a tool of oppression. And maybe for the viewers, just to refresh in their mind that the Supreme Court findings were to the effect that military courts have no capacity to guarantee due process, to guarantee a fair trial. They are composed by ill-trained people with zero knowledge of the law, and they cannot administer justice. The judges at the bench in the military courts have no guarantee of security of tenure, so meaning decisions can be controlled by the army command, because the army rules by order and moja in the army. So if you are told on the bench, like we are hearing a rumor that they have been told to give Besigye a death sentence, and that's why the CDF was always talking of death, hanging. So it was already, the sentence for Besigye was already known and being communicated to prepare citizens for when it arrives. Such is not a fair trial as envisaged in our constitution, and the courts upheld so. The Supreme Court decision breathes life into the constitution. It's what our constitution says. If we had constitutionalism, we wouldn't have degenerated to the situation of use of martial law or trial of civilians in military courts. And for a bit of a flashback, Idi Amin in 1973 started military trial of civilians in the military courts. By 1975, the civilian courts had been rendered irrelevant and all cases were going through military courts. So Idi Amin ruled under martial law. I have just shared on X that there are lots of similarities between NRM and Idi Amin regime. Key among these similarities is that they captured power on the same day, although NRA then postponed the announcement to 26 January to avoid the coincidence of 25th January, but I think fate had already taken its effect. So this fate of 25th January has really been haunting us as a country on several fronts. The UPDF, the NRM, when they came with a lot of praises, they were celebrated, not only in Uganda, but globally. The new breed of African leaders, the efforts to build a national army, because previously we have had regime armies. An army is dismantled as the regime is overthrown, a promise for peaceful change of power that we are yet to see after 40 years. You know, professionalization of the army. Many stakeholders have invested in the building of the UPDF as an institution. It's very unfortunate to watch any single person seeking to use the institution or even to refer to it as my army. The mindset, my army. Then seek to use it for personal benefit. The efforts of donors, the efforts of Ugandans, the goodwill of Ugandans, the men and women who have sacrificed that Uganda can achieve and enjoy benefits of a stable professional army. I know that people are celebrating Tarehe Sita, but what is there to celebrate? So when you have a decision of court, whether good or bad, legally a decision of court, if you don't agree with it, and you have room to appeal, then you appeal the decision of court. That's what the Attorney General did 4 years ago when the Constitutional Court outlawed trial of civilians in the military courts. He appealed, went beyond a 5-man bench to a 7-man bench, and woman, when I mean man, I mean both man and woman. Majority were women, and we celebrate the lady justices. They made us proud. So he went and appealed and lost flat. Even the one judge who dissented not fully hearted, was just in the middle. Generally, there was consensus that courts have no capacity to administer justice. It was a role imposed on the army. And to make matters worse, you have a bench of so many men in uniform, none of them is even a lawyer. Then you have an advocate judge in the corner, whose role is to advise. And previously, especially for young Ugandans, the court-martial of General Guti, the court-martial of the late General Tumwine, and others, the advocate judge would never utter a word in court. An advisor is a silent listener who can then go and whisper to the bench. That is the role of judge advocate. But the arrogance of the current court-martial that is now defunct, with the advocate judge usurping the functions of the bench, is really disgusted and alarmed everyone. And maybe that's what caused what Dr. Ojambo called as a surprise, the decision of Supreme Court, because matters had gone extremely out of hand.
Thank you very much. Honourable George, your quick thoughts. I know at the regional level also there are lots of conversations about the judiciary in general, the state of the judiciary across in all the member countries. When you see this kind of ruling, but I'll still ask the same question before we actually go into other things. Was it early for us to celebrate? What do you think the journey looks like? But I would like you to give us, to speak to this within the context of the region.
Statecraft is a very complex thing. And I always say that no friction, no traction. Where we are, we have, as Ugandans, been given an opportunity to have a robust conversation about our institutions, the principle of checks and balances, and how these different organs function. Providing checks and balances means that there is a fair amount of independence of these institutions, but they functionally reinforce each other. Where there is no meeting of minds, like in the case of this ruling versus the president's position, it gives us an opportunity to then interrogate the relationships that exist between the different arms of government. And you know, for the last 4 years, when the judges didn't make a decision on this matter, I think that it was very unfair to Ugandans, because we would have had this conversation 4 years back, and maybe by now we would have done everything possible to make sure that we plug in the gaps. The judgment has very specific elements. I have not gone into the depth of it, but I know that it talks about jurisdictions. It talks about the competencies of the court. It talks about the composition of the functional relationship between the court martial and the civilian courts. These are really some gray areas that we need to interrogate as a country. And indeed, I'm also glad actually that the president has put it in black and white, what his thoughts are. And you know, like I said, statecraft is a very, very complex matter. It's a delicate balance of interests. And if you are the chief executive, you are balancing so many interests. And you'd want to see that you want to have a stable country. On one hand, you want to ensure that you inspire confidence in the population that nobody can destabilize the country. And yet, on the other hand, you also want to ensure that our justice system functions and that people are happy that they can seek justice through our justice system and be able to get it. Now, I do not see doom. I see an opportunity. I see an opportunity because the judges, almost all of them, have made a decision on the matter, and they all agree that the court martial in its current formation, including its scope of work, is illegal. The question now is, how do we then balance the boat? On one hand, the president's argument is premised on security, largely on security, because his argument is that, oh, you know, there have been cases where those who breach the law, who are in possession of military
firearms and so
on, have been taken to court, and then, you know, either the court takes too long or that they get away with it. The the courts have told the president that you cannot have your cake, you can't eat it and have it at the same time. That there is supposed to be, if you are conflicted because you have an interest in the case, then there should be another organ that should be the neutral arbiter in this case. So, for me, I think that we are going to reach a point where there's going to be the meeting of minds, where the president, together with courts and us ordinary Ugandans, will build consensus on what is best for the country. When there was no conversation like this one, I thought it was very toxic. Number one, the passions were being inflamed. People were getting frustrated because our justice system was not delivering. And many people who had gone through the military court-martial felt that they were not being fairly, they are not going through a fair judicial process. So now, an opportunity has come. The president, who is the chief executive, has given his position. The judges have given their position. We must now, as Ugandans, see what is in our best interest. What is in our best interest. And indeed, if the Constitution provides that the military is supposed to be subordinate to civilian authority, I see a situation where the military will have to recalibrate its approach on matters of the law. Recalibrate its approach on how it deals with the criminal matters. So I am hopeful. For me, I am very hopeful, and I'm very happy that the judges made a very courageous decision. And I'm also very happy that the president has made his position very clear. And this now provides us with a basis for discussions. Trouble in this country is that most times we are so passionate about certain things and also emotional about them. And then in the process, we fail to rationalize them. There is no amount of emotions that can move our country until you transform that emotion to something rational, very tangible. So if there is going to be anything that is going to move this country forward, it is going to be the rational processing of the ruling of the court. No emotions is going to change anything. Whether the president, whether the ordinary citizens, whether whoever, it has to be rationalized, and then that becomes the instrument that guides us moving forward. And I see forward traction.
Thank you. Thank you very much, Honourable. So I'm coming to you, Joseph, but Honourable's response also preempted a question that I had wanted to pose earlier, which is basically your interpretations of the president's statement and whether or not this signals a kind of resistance to judicial independence. Joseph, that will be for you now. As you, of course, you can start with the question I raised prior, and then you get to that.
There is nothing judiciously conscious about Mr. Museveni. Yesterday, Thursday, marked 44 years since Mr. Museveni opted out of the Fifth Estate, the mandate of the people, we the people, opted out of the judicial process that was then very clearly available for him in Barara, and went for what he knows very best and very well, and that is the military. So he went to start a very atrocious war in Luweero. It's no coincidence that when the justices made their ruling last week, Friday, part of Mr. Museveni's spoiling of my party with his statements was an insult to the people of Karamoja by enjoying how much young Karamojong victims of NRA political and economic failures and social failures who find themselves outside the law are guests of his estate. So clearly A friend of mine in the NRM, I think last week, a few days after, I think this week, a few days after this ruling, and in a related conversation, was saying that we do not read the true Mr. Museveni, so the citizens of Uganda. So we've consistently got him wrong. He's very open, very honest. He doesn't tell lies. But somehow many Ugandans, almost like zombies, basically follow the guy, thinking that they understand the guy, but the guy keeps on telling us the truth. So basically what he said was very clearly the case. He's never believed in the rule of law. This constitution, which is basically broken to his convenience, designed for him anyway, was basically designed to basically legitimize his military conquest of January in 1986. Give some kind of legitimacy, but it's not very easy sometimes to try and pretend to be what you're not. So it's not surprising that this constitution has been used and abused as it is. But that said, I must say that I was pleasantly happy. Surprised is neither here nor there, because I want to give it credit. I was pleasantly happy with the ruling, because genuinely, and we've had this conversation here, I was one of those who were not very sure which way it would go. And Sarah sometimes to credit for this panel, and led by Sarah, when we've sometimes, invoked, Chief Justice Owindolo's name on this panel, on this very particular matter, as my brother suggested, 4 years was a very long time. And I think while they've given us splendid rulings, I hope never again in this country should a matter of such import take 4 years. When particularly as it happens, you have this fantastic men and women, particularly justices, particularly the female justices. These ladies made me and make me absolutely proud citizen, and absolutely proud of them, and absolutely proud of the possibility it's actually possible to go to a primary school, go to a secondary school. If you don't go to a UPC secondary school, girl child, helped and supported ironically by John F. Kennedy in the early 60s. Go to universities, graduate and become a justice of the Supreme Court and excel like this lady. So fantastic news. So these guys did a fantastic job. The reality though is that it was 4 years too late really. It should not have taken this magnitude of time. But yes, granted, this is where we are. As you suggested, that Chris Magezi thing, for me initially I thought it was fake news. Turns out it wasn't fake news. And Mr. Museveni's own reactions aside. Now, as I said, you asked Dr. Ojambo, is it too early? I think that's in a way that's part of the worry, and maybe your nuances towards making your emphasis to remind us that we don't know. We genuinely hope that with the reaction of Mr. Kirio and Mr. Museveni's Attorney General, comic as sometimes they can be, that they really follow through this thing, and then we will again wait and see what happens over the next few weeks. One thing that ought to have happened, is that yes, the justice needed to have been much more precise, explicit, and in fact instructed, who are instructed that the messages be released, that even particularly considering the nature of this case. It's shameful that the messages spent Friday. It's shameful that they went Monday. It's shameful that just 1 week later they're still in custody, and it's shameful still that the rulings, as it were, as definitive as they were, they're not explicit, and now work is for lawyers and judges to play around with this. But no, that we came out with it last Friday. I am relatively happy, but Judith, activism works. However long it may take, activism works. Mm-hmm. Civic engagement and activism work. We must credit this to part of public opinion and definitely activism, including Honourable.
Mm-hmm. Thank you very much. I'll get back to you about the same, Dr. Ojambo. When you read the President's statement hours after the Supreme Court ruling, how did you process it when you saw it? What was your interpretation of it? And do you think in any way this sends a signal that maybe it is a defiance or basically an undermining of the of judicial independence?
Yeah, I've studied President Museveni for some time, and he's a one-directional individual. In most cases, he does not want to move away from his line of thinking. The president's line of thinking on courts has been that one direction. This is not the first time, you know, his views about bail, you know, his views about these, in fact, he used to call them UPC judges until recently, that now he has started appreciating that there are some cadre judges. In fact, he's the one who brought that term, cadre judge. Cadre judge. I don't know whether students at the law school normally study them. So we're looking at it, it was him, really Yoweri Museveni in his real terms. You know, just a few months ago, he had also disagreed with another ruling. And this time, the ruling was ridiculous. The ruling was ridiculous to me, because at that time, they didn't say that these courts were illegal. But the ruling was that if a matter has been decided on in the general court martial, you cannot appeal it in these civil courts. It is only after this Supreme Court ruling that I understood those justices who said so. Because they did not see, you cannot treat a sheep's thing in the goat's kraal. Because the other thing they were sheep. Now you cannot bring them in the goats. So it is only it was only after this Supreme Court ruling that then I understood the other characters, the logic of the other bench, which ruled that you cannot bring that matter this way. So the president said no, and he wrote a long statement explaining that if you are not satisfied with the court martial, you can go ahead and appeal in the civil courts. But maybe, Sarah, they need to guide the president that he cannot change what the justices have ruled.
He will be fine.
The only thing he can do is maybe to put on combat and declare a military government. But so long as he professes a democratic government, the arms of government are very clear. There is the judiciary, there is the parliament, and unfortunately, he's even subordinate to some of them. The president, for example, is subordinate to the parliament, and is subordinate to the people of Uganda. That is the most important. So I was not shocked with his line of thinking. He's entitled to his way of doing things. And as a Ugandan, as a voter in this country, he's entitled to his opinion. And as a leader, he's entitled. But how much effective it is, that's where the problem is. Because his disagreement with the Supreme Court in real legal terms has no effect. Because the other one is the Supreme Court. The only thing he has now to do, if he does not agree in courts, he puts on combat and he says that this one ends henceforth. But for now, the Supreme Court thing is the thing. And he advised that he was going to, in fact, he did not advise. He frog-marched the Attorney General to quickly go and write something and take it to Parliament. And you saw how members of Parliament were angry. I saw a few of them
They are
asked.
meeting in the Interim Caucus. He has summoned the caucus.
Yes.
27.
But he forgets one thing. Me, I didn't go to a law school.
I will attend.
You cannot amend that judgment. That judgment cannot be amended by anybody in this country. You can only implement the orders. And therefore, the only clear orders that are there are one, that if you want that court to function and handle criminal offenses, you must, first of all, constitute it properly. Because they said it was the way it was constituted was unconstitutional. Because courts are constituted in a certain article of the Constitution, and the court martial was not there in among those courts of jurisdiction. That is one. Two, after you have formed it, not even constituted.
It's not, just for information, Dr. Jambo, it's not a court of record. Article 129, clause 2,
Yes.
defines the courts of record as High Court, Court of Appeal, and Supreme Court.
Yeah.
It's not a court of record, but if it qualifies as a subordinate court, then it should be constituted properly. And the most it can be is Chief Magistrate level. It cannot be above High Court.
Yeah, that's the first thing. Then the second thing, they also advise that if you wanted to try criminal matters, you must have proper procedures of how the bench is constituted by qualified people. In fact, Justice Owindolo gave us an analogy that you cannot pick a qualified lawyer on the street, then take him to theater to do an operation. He may not differentiate between the liver and the lung. So the kidney and the other one. So because of that, they were advising that you need to get people who are qualified to do that job. So that's what the president, that's what the lawyers can do. But changing the ruling, I don't know. But you know, NRM sometimes can give you surprises. We need to wait and see what will happen. But for me, I was not shocked by the president's comment, because that is him. That is him. If you start reading him from his mustard seed stories, then you have been watching him lead the government from 1986 up to today. He's a man. In fact, one time they had a huge argument with John Nagenda. And John Nagenda was saying that, Mr. President, you don't believe, in fact they were arguing over Mavira, you don't believe that you have never ever been defeated by other things, but I want to remind you, and I quote late John Nagenda, he said, you lost a battle to your death of the mother. Didn't you lose? And the other one, he told him where he has lost is when he contested in an election and he only got one member of parliament. So the president in most cases does not want to be on the villain side. He always wants to be on the victors. And that's why he has accelerated himself to wherever he is. In most of them he has achieved, but some of them he has failed. And I think on this one, if he really believes in democracy, he's going to fail.
Thank you. Let me come to you, Dr. Sarah. Of course, as you talk about that, I'd also, you know, the question that most people are actually asking is about compliance. The ruling is there, but it is not self-enforcing. How do you ensure that there's compliance with that ruling?
You know, the president in his letter starts saying, I've been informed about this wrong decision of court. And then the son has carried on with the same narrative, but of course in a not properly knitted way like the father. So when the president says that I've been informed about this wrong decision, what Ugandans should ask him is what is the right decision and who gave it. Because the doctrine of separation of powers is enshrined in our constitution. The work of the executive is to protect the constitution and protect laws. And the other work of executive is service delivery. The duty to make, that's Article 99 of the Constitution. The duty to protect and promote constitutional governance is the function of Parliament, on the other hand. Plus the other duties of appropriation, oversight, and the rest. And to make laws is Parliament. The duty to interpret laws is judiciary. So when the president says courts have made a wrong decision, who has the right decision? Because it's not him to interpret laws. He doesn't have capacity. And by training, he's not even a lawyer. So the president was briefed according to credible sources, was briefed on 24th of January about the decision of judges. Quarreled. Just it was courteous to brief him. He quarreled. He thought judges would change their mind. So when he says the Attorney General called me and briefed, yes, it's a good thing. Because what he was briefed about is behind the scenes. It's a good thing to try to show, of course accepting defeat, to try to keep face that you have not been defeated. But in doing so, you are undermining the Constitution. Article 99, the presidential power, executive power, is derived from the protection of the Constitution. So when you undermine the Constitution, you are undermining your own power. And Ugandans should remind you so. The problem is that Ugandans don't know the Constitution. But any president who undermines power, the same way the president is undermining a decision of court, he is undermining his own power. And if we had a serious parliament then, whose duty is to protect the Constitution and ensure constitutional governance, an impeachment motion should be on the floor of the House. Because the president has no power. His power is in the protection of the Constitution. So we should not be discussing impeachment of President Museveni. But he's lucky he has killed institutions. And when the Supreme Court tries to breathe, he's shocked. He's still processing the horror movie and crying and lamenting. But there's nothing he's going to do. Article 92 of the Constitution is to the effect that Parliament cannot legislate to defeat a court judgment. So even when he cries, he calls the caucus, they cannot legislate a law to change a decision of court. If they dare do so, because most of them might not know the articles I'm talking about, we shall challenge it and it will be scrapped off the laws of Uganda. Because it will be unconstitutional to the extent of the inconsistency with the Constitution. So even if he calls the whole caucus, even if the whole parliament is blind about the Constitution, they are supposed to protect. Even if they sit in their own understanding and enact a law to defeat this judgment, that law will be squashed by the same courts.
Thank you. Thank you, Dr. Sarah. Let me come to you, Honourable. Still on the same issue. When you have such utterances from the head of state, and I'm still picking from what Sarah said about the separation of powers, what is the implication of this?
You know, I don't think it is out of character to agree or disagree with the ruling of court. I am very sure that this very panel maybe at one point disagreed with the ruling of a court. The difference could probably be that one is a chief executive of the country and the others are citizens, but we are all citizens. So the issue of disagreeing with the position of court is normal. That's why I want to be the president's spokesperson here right now on this small matter of whether or not the president is right to disagree with the court. I think it is...
Disagree but to respect.
Exactly. So that's where I was coming to. I said, you know, it is okay for the president and or any other citizen to disagree with the ruling of court, but you respect it. The president so far has disagreed with the ruling of court. A statement has been made on behalf of the president by the Attorney General that the process of implementing the court ruling has started, meaning that he is respectfully disagreeing with it. So, for me, the biggest challenge would be if the president defies the ruling of court, that would really be, we would be going into a constitutional crisis, because then it would be placing the executive against the judiciary. But if the president says, well, we are going to implement, I disagree with the judges, I am not happy with their judgment, okay, but the Attorney General, please go ahead and implement the decision of the courts. That is well and good. We cannot agree on everything. We cannot agree on everything. And the president is human and he has a responsibility to provide leadership. And because he has a responsibility to provide leadership, he must have an opinion on matters that of governance in the country. He may be right, he may be wrong. Now, what we are dealing with here is whether, what is the impact of his opinion given his position as the chief executive. You know, our constitution gives a lot of powers to the president. The framers of our constitution also, I think, went overboard. They heaped a lot of powers
Overzealous.
in the presidency. So the president exercises a lot of power. And I think that's why when he makes statements like this, even when he has said he does not, he is only disagreeing with the ruling of the court, we feel, because we know how much powers are vested in the presidency and how, if somebody is very careless with them, can be misused. But what is the remedial action? You know, there are fears that the NRM caucus is going to see it, and as doctors say that, oh, you know, they want to change the ruling. There is no way, there is no other authority that can change the ruling of the Supreme Court. There is no other authority that can change the ruling of, unless if you want to overthrow our judicial system. But for now, no. And even if Parliament amends that specific legislation, it does not work retrospectively. So you first have got to implement the prayers of court. I mean, not even prayers of court, the orders of court. And then thereafter, you can make amendments. And that is for the future. And that is now a conversation that is for Ugandans. It's a completely fresh conversation. That's why I say that, you see, no friction, no traction. Maybe this is an eye-opener for us to say we need to entrench certain positions in the law so that it's not easy to make certain amendments within the law. But the law is there too for managing society. So what we should be doing is to persuade Parliament to say, please don't go in that direction. Okay? Let us agree and disagree with the President, but preserve the sanctity of the Constitution and respect the institutions. Because that's what makes us a democracy. If we are really a constitutional democracy, then we must allow the courts to function. We must allow our judiciary to function. You know, we must allow Parliament to function. We must allow the executive to function. In any case, they are supposed to be functionally supporting each other, in spite of the independence of each one of them, checks and balances. So that, for me, should be the conversation that we should be taking into the caucus, into Parliament, yeah, that we cannot legislate on every matter. Then we run the risk of over-legislation. So if I disagree on this matter today, then I run to Parliament and we change. Then tomorrow there is something else, then you run to Parliament to change the law. You can't keep changing the law like that. That is constitutional instability. you know. So if we want a country that is stable, then we must have these conversations where we agree, we disagree, but we maintain the principle and make sure that we preserve the sanctity of the laws, the constitution, and the institutions that govern us. Yeah.
Thank you very much. We just have a few minutes to take a break. But I'll come to you, Joseph. And I want us to go back in time a little bit, historically. If we could just, and I know Dr. Sarah had earlier hinted about the past, the 1970s during Idi Amin. But I'd like us to explore this relationship between the military and civilian courts and see if historically there's this recurring tension that perhaps we are also seeing in our present times, and how matters were resolved at the time, and perhaps try to draw some lessons from the past and see how the situation can also resolve itself in the present times.
I think that's an important question, and possibly you'll be surprised that I'm saying that I might be the wrong person, because I'm going to defend the past in such an objective and fair way that people from NRA side will not believe.
I'm not so sure about that.
But in 4 minutes, though, then we
yeah,
shall
yeah,
come back and we'll
I'll
continue from that, yes.
No, look, I must say that Mr. Museveni disagreed absolutely disrespectfully, because he actually abused the office of the president. What normally happens, and you know, I'm lucky, as you know, quite been around some of the spaces, including distance of other parliaments, including Ugandan parliaments under UPC. Presidents are very careful with their words. Prime ministers are very careful with their words. On the basis of the question of separation of powers, what I expected from Mr. Museveni was not to insult the Karamojong and to insult actually the judges, you know, and to invoke some kind of legal authority that he doesn't have. Mr. Museveni's economics from Dar es Salaam University is actually questionable economics, considering how he's actually ruled this country over the last 40 years. So what he ought to have said, and since you're offering to be his spokesperson, I would offer to be his speechwriter in the future. That, look, you know, I disagree, or we disagree, you know, with the ruling, but we shall respect it.
Yeah.
You know, that is an extremely important statement from a head of state. I see prime ministers and presidents all around the world. That is to emphasize, and they would go ahead and repeat, particularly if they want to boast about it, that, you know, for us, we respect rule of law and we recognize, you know, the separation of powers, that, you know, and the independence of, in this case, of the other arms of government. And he would have actually come out much more strongly, much more powerfully, much more authoritatively, and would have gone ahead and argued, made the arguments that he talked about, that, you know these things, you may not agree, but they helped us with this Karamojong, although we stole their Mabatis, and you know, we did not try some of the thieves in my cabinet in court-martial, things like that. But anyway, that's the by the by. Look, except for under Idi Amin's time, I do not know in the two or better administrations that I know and I'm familiar with, or perhaps including interim administrations, including the ones in which Mr. Museveni was serving between 1979 and 1980, I do not know any circumstance under which there would have been an abuse of the institutions of interim parliaments, or indeed the judicial attack on the judiciary like has happened under this regime. Away from what Sarah said, the only thing that is usually repeated is the consultative element of the 1966-67 Constitution, what they call the pigeonhole thing. And the nearest they say is that there were soldiers out, you know, around Parliament. And where I would go ahead and say, yes, considering the fact that Buganda was actually armed and ready to break out, it was certainly in that kind of state, you know. But still people found that generally quite unacceptable. And it's a conversation that I would sort of concede. You see, in the 80s, this guy was here in the bush in Luwero, not a single member of parliament, you know, you guys would have been much younger, not a single member of parliament, not a judge. In the 80s, from January 1981 up to 1985, there was never a time in which a serving member of parliament, a judge, would have faced any of these, scintilla of these other things. Chief Justice, fantastic guy. Attorney General Stephen Omodinga Rico, fantastic guys. These things, no, it did not happen in the 60s. It did not happen in the 80s and about. In the meantime, we knew Amin was a dictator. And Amin was a military man.
And so we don't want to get persuaded to go to create any comparison. But I can tell you authoritatively, including in the interim administrations post Idi Amin, in which case, the UNLF government, in which Museveni was serving as Minister of Defense, was faced by insurgencies and trying to stabilize the country with Amin and others. None of these things happened, except I know one single thing was the Pandagari that Museveni started as Minister for Defense, targeting Baganda youth. And it was Mr. Museveni, it was not the interim UNLF government who did the thing. Not anything like this.
Thank you very much. Let's take a break and then we'll return and continue with this discussion, exploring the challenges following the recent ruling by the Supreme Court that it is unconstitutional to try civilians in the military courts. This is the Chat Show.
Digital rights are those human rights and legal rights that allow individuals to access, use, create and publish digital media or to access and use computers, other electronic devices and telecommunication networks. Digital rights include a right to freedom of expression, information and communication through technology, a right to privacy and data protection, a right to credit for personal works, a right to universal and equal digital access, a right to identity, a right to anonymity, a right to be forgotten, and a right for protection of minors, among others. The state's digital rights are frequently violated through various unfair actions, for example, blockage of websites and social networks, theft of credentials, unauthorized use of people's data for personal gain, privacy intrusion, online censorship, arrests and intimidation of online users, internet blockages, and the proliferation of laws and regulations that undermine the potential of technology to drive social, economic, and political development worldwide. It is hence every citizen's responsibility to respect rights of other digital users and to speak out or report to the responsible parties when one's rights are violated.
Welcome back, and we're glad that you're still with us here on the Citizens Chat Show. My name is Judith Atim, and we're continuing with our discussion on the challenges of implementing the recent ruling by the Supreme Court that says it is unconstitutional for civilians to be tried in military courts. And before we went to the break, I had posed a question to Joseph, and now I'll throw the same question to Dr. Robert Ojambo here. I want us to look at the historical relationships between the military and civilian courts. Dr. Sarah had already alluded to the situation in the 1970s, and I just want us to go back a little bit and also try to connect the dots and see what lessons we have to learn from the past and the present.
Yeah, thank you so much. For you wanted us to move from 70s. I will take you a little bit lower. And this was the time when we had a colonial government here. And the Kabaka of Buganda is deported in 1953 to Britain. You need to look at who was fighting for him. Yes, the Buganda activists were doing a lot of work, but legally, majority of the people who struggled for the Kabaka were British lawyers, barristers. And they staged a real good show in England. And it really made the British look very ugly here. So because of that, later it is decided that the Kabaka comes back home. And the British colonialists, as they were, they accepted because it was becoming messy. They really showed how he was taken. In fact, they started from, for those who want to understand the Vesije kidnap in Kenya, you just need to go and read that story, because even the Kabaka was kidnapped. You deceived him that they were going for a meeting in Entebbe. When he reached there, they kidnapped him and they bundled him in the UK. But the lawyers used those weaknesses until they defeated the British government and returned the Kabaka. And being colonialists, you would imagine that they would just say rubbish. We cannot do this, but they respected. I have those scripts on my table. I can share with anyone who wants to read them. The first government of Uganda, 1960, that is one of the best governments we have ever had, 1962 to 66. And even when you look at the economic performance, everything, they were doing very well, those gentlemen. The parliament, if you read the Hansards of 1962 to 66. Perfect. You wonder. These guys, majority of them were not even graduates. I think there were about 2 graduates there. The ones who had really gotten degrees, but majority of them did not have degrees, including the Prime Minister did not have a degree. I know Mr. Ochieno is not going to argue with me here.
I don't have to argue the facts.
but the way they handled the things, remember that time, even the people who were in our courts were not Ugandans, the Udoma and many other people. They were not even Ugandans. But there was a smooth running between the executive, the judiciary, and the other thing. The only trouble started after 1966. After 1966, there is no history to write home, which was good. Because there, now, the state was not normal. My colleague here talked about statecraft. That's when the statecraft started doing its bad things. The military became very powerful. The courts almost started not saying anything until we went. You remember, we were supposed to have an election, but because of the things that were happening in Uganda, we couldn't even have an election. So 1980, 79, 71, there is Idi Amin. During Idi Amin, again also there is nothing to talk about because he was using military tribunal. For him, his thing was military tribunal. Every case went to military tribunal. And the decrees. So when we came back, we tried to settle. In UNLF comes and 1979, we tried to settle, but that period going into election also had a lot of science. They used to call it UPC science. Science of the Rugumayos, there is science of the other group, there is science of the syndicate. And therefore we go into an election when already there is a friction. When there is already friction. And the people even know who is going to win an election. Because the president, how did the president know that he was going to lose? By saying president, I mean President Museveni. He knew he was going into an election, but he was sure that he was going to lose it. And he promises that if I lose this election, I will have been stolen and I will go to the bush.
But Dr. Ojambo, for the benefit of young people, President Museveni in 1980 with his group, they were like, not like Katumba way, but they were, they didn't. They didn't.
I didn't want to go there. I didn't want to go there.
What were you trying to say?
I didn't want to go there.
Okay, Dr.
Yes. So he prepares the people.
But my father belonged to that group.
Yeah, that he was going to lose an election. So what I want to say, from 1980, when UPC won election and formed a government, that government was never stable. Because 81, NRA declares to go to the war. And in a country where there is war, where there is a lot of confusion, if you read the books written by some of these NRA people, you are depressed. You are depressed, where somebody is praising himself that for him his duty was to make sure that people in Kampala go to sleep early. And that was the job of Matayo Chaligonza and Pecos Kutesa. That was their job, to make sure that people go to sleep.
Sabotage.
To sabotage government. And in fact, they write that one time they even wanted to go and ban the depots. They are writing these things. They are putting in their memoirs. Nobody that we are reading rumors, they are telling you themselves. So such a government, you would not talk about a proper rule of law, and you want to compare it with these other ones. What we want to do is to deal with when a person serves you food, you should eat with him or her that food. In our African tradition, you don't serve us food and you walk away. NRM promised us that they were restoring democracy. If you read the swearing in speech that was given by our president, he said that it was not just a mere change. It was a fundamental. In fact, he said, I think it is a fundamental change. And he explained what fundamental change was going to involve. It was going to involve constitutionalism. It was going to involve democracy, it was going to involve prosperity and these things. So, given that check, that balance check is what we measure NRM. We don't want to measure him with a mean. We don't want to measure him with some instability behind there. We want to measure him in respect of what he promised, and we tell him, good man, you have done your best, but here you have failed. This is what for us academicians we do. So we shall tell you how it is, not how you want to hear it.
Thank you.
As Dr. Ojambo was presenting, I tried to, pick the 10 points program. We have since forgotten them.
Number one is
because
democracy.
the regime moved away from them. And quickly, if you may allow me, number one, democracy. Number two, security. Number three, national unity and end of sectarianism. Number four, national independence. Number five, independent, integrated, self-sustaining national economy. Number six, rehabilitate social services and rural ravaged areas. Number seven, elimination of corruption. Number eight, redressing historical injustices and developing Karamoja. Number nine, cooperation of African countries. Number 10, a strategy of mixed economy. So after 40 years, whenever I mention 40 years, I just recall that Museveni came to power when I was a baby, 7 years old. So now I'm gray-haired. Don't look at my hair.
It's fantastic hair, by the way.
No, if you want to see the sample, look at mine.
For the record, you guys are viewing, I'm just a meter away from Sarah. The hair, absolutely fantastic.
Proceed, Dr. Sarah.
Yeah. So, it's such a long time.
Sarah, can I tell you something?
Yes.
We teach those 10-point programs to our students at the
I'm
university.
sure they get shocked.
And when you are teaching, they are laughing.
Yeah.
So 40 years, those are pretty much 2 generations.
The first book I read is Why We Waged the Protracted War by YKM7. I've been looking for it. I don't know where these books went. Why do books disappear?
No, they have disappeared.
They are
They have even disappeared from the library.
Because they've been found out.
When you read that book, these guys mastered propaganda. Propaganda that would really twist the minds of Ugandans. I'm glad also that among the books I've read, I read Mzee Chango Macho's last manuscript.
Yes.
In that book, that manuscript, he explains how these 10 points program were formulated and how it was propaganda. When they realized that Kampala was about to fall, then they said, what do we tell the people?
So in other words, they didn't actually believe in the 10-point
No.
program themselves.
That's why I'm very glad that I read Mzee Chango Macho's last book, because on his deathbed, he told the real truth. So, wow, what do we tell the people if we capture government? What's the program? Then they sat down. He was among the main architects of the 10-point program, driven by his socialist ideas that you can see very well in the book. So convincing, and then they were adopted. And that became the program now. It won't be a mere change of guard. It will be a fundamental change. The other important statements that go with the promise of fundamental change, other than the 10 points program, is a promise of a peaceful handover of power, which we are yet to see all my life. All my life, I'm yet to see that promise of a peaceful change of power. And I still believe that it's not too late for Mzee Museveni to deliver this gift. With a lot of distortions along the way, but it can still be done. Because this gift should have come in 2006. So it has been postponed for 20 years. If he wants, like he's going for another election, of course, which is a mere exercise, We know the winner, like Dr. Ojambo says, when you go for an election, when a winner is already known, what's the point? So we already know the winner. So if he can use these 6 years to say, these years on his, as he takes a new oath, these are years of transition. I'm going to do nothing else but organize a transition. It will still be a welcome gift. It is not too late to do the right thing. It will only be too late when he is no more. So if he can still deliver that gift, like we were saying that this Supreme Court decision has cemented Justice Owinedoro's legacy. Nobody can take it away from him. He will always be a celebrated Chief Justice, regardless of what else has gone on. So if President Museveni delivered this gift, however late it is, we shall celebrate him as the first president to properly hand over power. So it can still be made. Please take that message.
Yes. Will you take that message?
The character of the state reflects the character of the leader. You see, I know that there is an academic, very academic assumption that institutions are more powerful than individuals. But institutions reflect the values of individuals.
Correct.
And in the absence of individuals, there are no institutions. Because institutions are just values, and those values are embodied by individuals. Now, you need to study the character of President Museveni to understand, because we're talking about the history.
Yes.
And maybe even look at it with the character of liberation movements in Africa. Whether it's Frelimo, whether it's CCM, whether it's ZANU-PF, even ANC now. Okay, you can go on and on, especially in Africa. They have the same DNA. Whether you go to South Sudan, which is SPLM, or you go to Rwanda, RPF. Take time, study these organizations. They could be nuanced a little bit, but fundamentally, they have the same DNA. But let me come to the character of President Museveni and why his character influences the character of the state that he manages. And until Ugandans understand this, we will still be grappling with Musevenism. During the Luwero War, President Museveni then was leading NRA, and Kaira was leading FEDEM. In the famous Chichusa meeting, a place in Luwero called Chichusa, they agreed to work together. So there was an integration of forces. So FEDEM joined NRA. Now, to cut the story short, the command structure of NRA did not change. They knew that movement that had already been integrated did not change. And it was predominantly Western, Banyankole, educated.
And Banyarwanda.
Okay, and Banyarwanda, because of the composition of the Banyarwanda. So, a few people began to spread a toxic narrative that, you see, we are being dominated by educated Western people, okay? They are in the rank and we are in the file of the NRA. And it intensified and actually caused some bit of cracks. It threatened to undermine the cohesion of the movement. And yet Kaira had a very good number of, and he also represented the diversity of the forces. So there were those within the NRA who insisted that the command structure should not change, because these people were saying we also need to be commanders. So there are those who say, no, but these people are not educated. They are not exposed. So we don't want, we are educated, we are exposed, we are more, you know. So when President Museveni came, he studied the situation and sat with his high command and said, no. We need to identify those within the Kaira group that have demonstrated exceptional leadership qualities, that have demonstrated exceptional fighting skills. We train them and promote them. So he co-opted them into the command structure of the NRA and brought them together. What am I saying here? That Museveni has always thrived, is at his best whenever there is friction. He understands people more whenever there is friction. Do not underestimate his capacity to emerge from a conflictual situation. And this has been the case over time. You're saying the 10 points program. Museveni understands that government is a moving target. He got off his Kodak moment long time ago. He is from analog. He is now on digital. He has now metamorphosed. You see, nowadays he even tweets.
Now he understands MBs.
Yeah.
People could be tweeting for him. Because there's that clip of Corona when he was asking youth, what are MBs?
You get it. So, what President Museveni has done over the years is to fashion the state. Okay? In his image. In spite of, so he knows that the courts must function. He is not going to undermine the courts. But what he will do is whatever he can within his means to ensure that he continues to be in charge. He will do it. Okay? He will do it because he sees, and that's the history of many of these liberation movements. You will see them.
Sorry,
yes, you have
if I
an
may ask
interjection.
something.
Yes.
You see, in a household, when you have a father who needs to remind people, by the way, I'm your father, you know that there is a problem. A president by nature is in charge. That's why he has so many titles in the constitution, including Fountain of Honor.
Yes.
Nobody has. So he doesn't need to do anything to maneuver, to remind people that he's in charge, unless he has lost legitimacy.
But are you aware that in the same family, there is a difference in the way you manage children when they are children, when they grow to become teenagers, and when they become adults? You manage them differently.
Which stage
if you have 3 sets of children.
Which stage would you say we are? Are we?
Yeah?
Which stage would you say
No,
Uganda is in?
I am simply saying that
Adolescents.
the president is one person who is very flexible and adaptable and adapts to situations. Now, we were talking about the military, the history of the military.
Yes.
Okay?
The relationship between
the military and the civil
courts, yes.
So you see, Idi Amin, like my brother Ochieno said here, that Ochieno said that Idi Amin was an outright dictator. You don't need even to. Okay? Museveni knows that he cannot go the Idi Amin way because Idi Amin is a dictator. So what does he do? He has to adapt to a new democratic dispensation.
He has to camouflage.
But Honourable, would you then say, when you look at, I mean, this historical explorations you're all giving, would you then say there's this recurring tension between the military and the civil courts over the years? Would you say that?
Yeah, it has always been
Is there a recurrence of tension between these two entities, the military and the civilians? And how then can this tension be resolved?
By the way, that's why I'm saying that President Museveni is a very smart leader. You are not just admitting this, because you wouldn't have a court sitting to determine how the military is conducting its business. And it even delivers its ruling in such colorful language.
What do you mean?
I mean, would that happen during Idi Amin's time?
No, not true. I mean,
Exactly.
I mean,
So because we're talking about history.
Yeah,
We're talking about
true.
history. Idi Amin is part of our history.
No, but we agreed Amin was a dictator, so what's the point you're making?
Yeah?
No, but
Would it
still,
not
we
be-
agree, but
because he's trying to tell me about the
I
history
am
of our
tr-
relationship
yeah.
between the military.
and he's open to explore
Yes.
whichever times, whether
Yes.
it was Amin's time or not. Yeah.
So I am telling you that Idi Amin's time, you would not have a court sitting there to determine how the military should conduct its business. They don't even have that time. Okay? President Museveni has put his opinion out there in which he disagrees with the ruling of court, but he respects it, because yesterday the Attorney General came before Parliament and admitted that a decision has been taken by Cabinet to make sure that the decision of court is implemented. So you can see that there is a complete difference between how President Museveni is managing, even when he disagrees. Okay? The military is not interfering. You have not heard that they have arrested judges or they have done this. They're actually complaining on Twitter, like any other citizen. You will see that Magezi will say, for us, we don't want this and so on. They are also tweeting like any other citizen. Okay? But that is the level to which Museveni has also stabilized the state. Let's give credit where it belongs.
Thank you, Honourable.
He has been able to stabilize the state, so much so that we can agree and disagree with the military and continue to have conversations around it and improve our governance system. Yes.
Thank you. Joseph, I know you're not a lawyer, but I'm still throwing this question. I mean, as a political commentator, as a citizen, I'd still want to hear your thoughts. What would you, if you, for instance, had a case in the military court, or someone you care about in the military court, what then would you say, how easy would it be to have these cases transferred and so on? Because, well, I know the Attorney General was in Parliament yesterday. He says he's in consultations with the Chief Justice on how this ruling should be implemented. He's also in consultations with the DPP. I think today I saw something to the effect that they were working on ways to see how the files are transferred from the military court to the DPP. From where you sit or where you stand, as an ordinary citizen without any legal background, how easy do you think this is going to be?
I've got some legal basics. Number two, I am the de facto president of the Uganda People's Congress. And so, had the judicial system been working, this is the matter that should have been resolved 4 years ago. And that tells you about the shambles of this NRA state, which is rather shaky when it comes to institutions of governance, including the judiciary. And the point I'm making here is that you cannot be president of a Uganda People's Congress, you cannot be president of an independent political party, you cannot be president of the only political party that has ever gained power with the mandate of the people in this country, and not have the capacity to appreciate some of those things. And so therefore, when I raise my concerns, I raise them with total authority. As I said at the beginning, we should really be here. I think those are the little gaps that the Supreme Court Justice last week ought to really have been very definitive about, and they were not. So I think that bit of it, I sort of leave it to the lawyers. In any case, I think maybe they're deliberate. I think the other day I was talking to an NRM insider, a political commentator, and the former close ally of Mr. Museveni, but fairly critic, and it suggests that possibly, amidst all these other credits we're giving to the justices, they needed to play safe, and despite the authentic clarity as suggested here, that maybe they also had to leave some kind of mini spaces, or else it was going to be likely a direct war between, in this case, basically they really didn't want to appear too bad in the face of Mr. Museveni. And as I said, for that they generally tried, did their level best. I generally don't know. In a state in which there is common sense, and in a state in which the executive is not using the nuances of the power, excess executive power, the chief of prisons would have been very uncomfortable that day on what he needed to do with the people under custody, following that ruling. And again, as you rightly say, you don't necessarily have to be a lawyer. But because of the nature of the whole thing, and because of the tweets of Mr. Museveni's son, and because of the tweets from the office of the Mr. Museveni's son's office, and because of the messages as the statements by Mr. Museveni, where he actually castigates judges and says that
the wrong decision,
not really wrong decision, but they don't control this country, part because of time, I don't go back and read that. It was so disparaging and actually quite scary. And that is why I'm saying the state of fear that Mr. Museveni puts on this country is a state of fear that never happened under Obote II administration, when this country was effectively at war, including bombs being thrown in Kampala. It never appeared. This is a military state wrapped up, and I totally agree with my young brother here that Museveni had to dress up himself in the manner in which he is. And number two, I also agree with you. Museveni started off as some, average Marxist in Dar es Salaam, to become now the number one Nyampala, the chief seller, the chief spokesperson and advocate of excess imperialist powers on the African continent, to the extent that Museveni claims he's a Pan-Africanist. But Pan-Africanists don't invade and occupy and control other nations. So Museveni, you're absolutely right, changes. So from that one to a man who amasses excess wealth, that Nyera and Obote would from the other end be very shy and perhaps feel embarrassed that they don't own 3, 4, 5, 10 cows. So that is the different kind of Museveni. And I also totally agree that Museveni is actually a fairly sharp guy, that when in the bushes, he knew he was using Luwero bushes, of the Baganda, and it was actually fanning anti-non-Baganda, anti-non-Bantu thing in Luwero. He obviously had to please these guys. And so he was cleverer than his commanders by saying that, okay, we can wrap up with these guys. Obote in 1990 rise and set challenges that these guys spent times in Luwero. So how many Baganda are majors? And today you can ask 40 years later, how many Baganda are generals? But in Museveni, they've got 3 generals, including excellent generals. So that Museveni, yes, Museveni will change and change with time. And that I totally agree. So today is he a capitalist? Because he's never been. Is he a socialist? He's never been. He's never really been a Marxist. And finally, I think one thing I also know about Mr. Museveni is that he was not necessarily a revolutionary, because NRA is not a revolutionary political organization. Number two, one other thing I also know about Mr. Museveni and his NRA was that they are not liberators, because there was nothing Mr. Museveni was liberating in 1981. The liberation political forces, as described from ANC and others, those are liberation political forces. The only last liberation in this country was on April the 11th, 1979. Whatever happened with Museveni in Luwero and whatever happened since January 1986 has been a net tragedy, manifested by the fact that Kizza Besigye was kidnapped from Nairobi and brought in here and taken to a military dungeon in Makinde and partly in Luzira prison, instead of being tried formally in a civilian court.
Thank you. Thank you, Joseph. I'll pose the same question to you, Dr. Ojambo. As an ordinary citizen in this case, what would you foresee as some of the practical challenges? If you had a case in the military court or you had a loved one there, what would be some of the practical challenges that you would see in terms of transferring the case from there to a civilian court?
Yeah, I have no training in law, but over time I've come to learn that law is common sense. It's just common sense. When you go to court there, you just see people talking common sense and confusing people that they are very complicated. Because when you read Owinyi Dolo's one of the orders, he said that the cases in the court martial cease. And I said, okay. But in the second statement, he says, therefore, all criminal matters should be transferred to the civilian courts where they can be tried well. I saw a judge confusing us.
Because you think law is common sense.
It's common sense.
No, it's
So
confusing yourself.
I had a conspiratory story, and it is good that he has confirmed part of the conspiracy, that there was no way Owinyi Dolo was going to give such a judgment without briefing the Fountain of Honor, a military Fountain of Honor.
It's been cut here.
So,
There is just cut
so I saw that they were opening, they were closing the door here and opening it this side. So my question has been, when I read those things carefully, those orders carefully, I discovered that, yeah, if Owinyi Dolo had all the powers to say that these matters have been handled here illegally, therefore they cease, and therefore they are quashed, and the people should go home. He had those powers.
But that would create a vacuum.
It will be creating. Yeah.
Now, it's good you are saying it could create a vacuum.
Yeah.
Now, the DPP, because if you are to take a criminal matter to the High Court of Uganda, you must go through the DPP.
Yes.
The DPP, therefore, you cannot transfer those files to the civil courts. You have first to give them to the DPP
For sanction.
for sanction. Now, you see, this is a Chief Justice. This is
Procedure.
yes, but you look at the process. How then do you take these
So
files?
you suggest the justice should have made the directive?
Yes,
That this
should
file
have
be
been very, very
transferred.
clear on what
Definitive
should
route.
happen. Because in this case, you are giving chance, and you know, for those who didn't study law, that in every law, when they are creating a law, they create a window where the person can sneak through. So that was trying to create, now these Chiriowa is the Attorney General, and others, because now you can imagine, the Attorney General is the one who had gone to court. He was the complainant. Now you are telling the Attorney General that please implement this laws of yours. You have just created a problem, because this person is a party, is already a party. So I thought that a judge who is an arbiter between the Attorney General and the people of Uganda, Kabaziburuka, and others, should have been a real arbiter and make sure that by the time you leave, these guys have been separated. Now, Parliament, I saw the other day, saying that Attorney General should explain, should organize, should do everything. Now, today, I've seen that they are going to give the files to the DPP. The DPP can take another 40 days and will say, I'm still studying the files.
Dr. John,
For 12 months.
If I may come in. So there were two options or two possibilities. One is that the registrar, court martial, could have written to the chief registrar and transferred cases. Then the chief registrar would send these cases to courts where they have jurisdiction. Because in civil cases, jurisdiction differs according to the facts on the file. Then the DPP would find the files there. That's one option that should have been done. But when you discontinue now the court, the other possibility is to say, stop trial, people whose release time or the time booked in prison has lapsed, like Dr. Besige,
Go home.
said release. So the Abashija on Monday should have opened door for Besige and Hajurutare. The police can rearrest them on the gate of Ruzira. Then they start the process of 48-hour detention. Then they produce Besige at High Court. So there were two possibilities, but these are just mere procedure. So when the judge said transfer cases to civil courts, he did not involve the DPP, and he knows what they know what they were doing. So the chief registrar should have written, the registrar should have written to the chief registrar, because that's an overall registrar. Then he will allocate those files. So as you transfer files, best they should have been, that's why I'm saying that Byabashija, when he failed to drop Besige at High Court, he's in contempt of court.
Precisely. Yes.
And I'm glad that at least there is a file of habeas corpus, although I would have preferred contempt of court, because we know where Dr. Besige is under Judicial. But they are now detained illegally. Prison should not concern itself with these arguments that we are having. For them, they should look at the detention orders. Somebody was detained till Monday morning. Beyond that time, you have no jurisdiction. You have no business dealing with them. So, Byabashija to engage in illegalities. I'm waiting for this, I'm waiting for that. He should be sued 3 times. One, contempt of court. There should be multiple suits against Byabashija. Contempt of court, habeas corpus has been filed, but also personal liability through the Human Rights Enforcement Act, because now he can be accused of abduction of Dr. Besige and Hajurutare. All 3 suits should be filed against him.
Thank you.
So just to finish my statement, you have heard Sarah argue like that. She is entitled. If today you called Byabashija to also give his defense, he will give it a very serious defense. So judges
That's
are
why
normally
we need competent judges.
judges
That's
are
why we
given
need very
judges
competent
are
judges.
given a role now to judge between what she's saying, and because Byabashija is also in a catch-22. Court martial brought this person and said keep him here.
But now it's
No, she's Commissioner General
It's
of the
advanced.
Prison Services.
But listen,
where things work, he should be able to know.
So why
even as
didn't why
he's
did
in
court
the
say
wrong
release? Why didn't court say release?
You wanted to say
that's
something,
implied
Honourable.
by their orders.
Yeah.
That's implied.
Yeah.
When they say discontinue, they don't need, you see, a judge cannot be written in detail of ABCD.
Yeah.
No, I have read
And
judgments.
where you don't
I've read
understand,
judgments
you
where
seek
they
the
say so.
interpretation of courts.
interpretation. And
You
in any
go
case,
back.
and in any case, if you don't mind, one other thing is actually for Kiroa. Again, perhaps this one we leave the justice aside. Kiroa is the Attorney General. If it was some private citizens, neither here nor there. If he knows he filed this on behalf of the state and is really, for heaven's sake, an Attorney General,
A
and
chief legal advice of government.
and we pay
Not
we
in
pay,
Uganda.
We pay.
That's what the
But that's the point
Constitution
of it.
calls
Of course,
it.
not under Uganda, under NRA, but under Uganda of a UPC administration. That nonsense wouldn't be there. Anyway, wouldn't qualify to be a Chief Justice. I'm telling you quite honestly.
Also,
You know,
we
on a
have
serious
about
note,
10
because
minutes
we
to
really-
go,
you guys,
and then just wind up.
Genuinely as a country, need to reach a situation, a state in which there is a civility in this country where people know what is happening, like it would happen in other average countries. In any case, actually, I said, he would know what he needs to do, and he doesn't need to wait for instruction from anywhere. And I think that's not for the justice. That's actually the incompetence from his own office.
So the best way to understand court directives is to extract an order of court. So I hope one of the parties, when the judges have been going through their conference, and your conference in a retreat, I hope that the next week, one of these parties will extract an order. An order is precise, does not need interpretation, and does not leave room for doubt.
Honourable, you wanted to say something. Let me give you the mic.
No, I want to agree with, you know, when the courts made a ruling, it's implied. All the other, officers, judicial officers, have to do their work. They don't have to go into the detail. Now, okay, from here now you go to the DPP, then from the DPP or the registrar do this. It's implied because that's your work. So the courts made a ruling. And now it's for the other responsible officers to process that ruling and make sure that everybody plays their part. Chief, they will not go into the detail of, oh, you know, now Besije or this and that. They will not go into that.
That's what they are doing.
No, because the prayers, the initial prayers, which was 4 years back, was on the jurisdiction of
Civilians, trial of court,
you get it? So they wouldn't go into
release this one,
this and that and that. No, they deal with the principle. Okay, so they ruled on that.
I think it was definitive
very
enough,
specific.
yes, to be fair to them.
Then it is implied by that ruling. These other things now happen. You know, the different procedures, the different officers will then process the court ruling.
Thank you.
But not in this country. Not in this one.
We need to wind up. We have just 8 minutes
Where
to
black
7 minutes
mambas
actually.
can even
So
attack court.
I am going to ask you, I don't know how, no, let me start
Yes.
from Joseph, then we come this side. Just conclusion. But you wanted to say something before? Joseph, please. The mic is yours as we conclude.
No, I'll choose not really to say much. No, this is a police state, and it's evidenced by actually some of the conversation we've just had here. No, I'm just simply praying and hoping that common sense prevails in this country over the next few weeks, that the people who are being held illegally by this military thing be released, and that lessons are learned, and that in future, Mr. Museveni, if he wants to have his political game with anybody else, he should actually have the civility and respect to make sure that if he's to arrest people, he should arrest people and then rein them in civilian courts and let the due process of the law take place. And to remind Ugandans that no, nothing we've seen in the last 12 months under NRA can be put together over 12 years of a UPC administration. And I'm saying so, do you know why I say that? Sometimes people think about UPC. I'm just trying to tell Ugandans that Museveni blackmails Uganda, and NRA, backed by some of their foreign friends, you know, blackmailed Ugandans of a dark Uganda before. So Ugandans can suffer under this rogue system. No, this country was ever better than this. And my point to young people, this country can and should and really must be better than where we are at the moment. That's my point.
Thank you very much, Joseph. Honourable Judge.
When the courts in Kenya annulled the elections, everybody said it was a groundbreaking
Ruling.
Yeah.
And they celebrated Kenya as an example of a functioning
Judiciary and
democracy and so on. And also recently, when the Gen Zs went into the streets, okay, in spite of the, you know, the viciousness with which the state responded, but still, they made their point, and everybody celebrated that, you know what, Kenya is you know, is gaining more traction, forward traction in terms of democracy. I think it's the same thing that we should be celebrating here. That it has been long coming, but finally this ruling, okay, has given hope. Hope is a multiplier, I can assure you. Hope is such a multiplier. It has given hope to those who thought that we do not have any more functioning institutions, our democracy is struggling and so on. We should be celebrating, even if it's one, you know, one score, it's better than none. So for me, I think that what the courts have demonstrated, that we are living in a place where we must continue. We must not give up. We must continue to widen the frontiers of the struggle for democracy and good governance. It is not something that you are going to get on a silver platter. We must continue to remind ourselves that we are a constitutional democracy, and there is nobody who is going to take it away from us as citizens of the country. Not the court, not the parliament, not even the president. We are all subordinate to the constitutional order that we enacted. Thank you so much.
Thank you, Honourable. Dr. Sarabi.
Yes, you know, knitted it so well together. But I want to borrow it from when Kenya courts nullified Uhuru Kenyatta's victory in 2017. President Uhuru Kenyatta was caught off guard and he was visibly angry. But he said, whereas I don't agree with the decision of court, I will respect it and go back to the people. He did not go into a hula balloon, you don't rule Kenya, you da 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 da. That is bush. You know, when courts rule, one side has won, another side has lost. There can't be two victors. So you need to prepare yourself. Once you are in court, you need to prepare yourself. It can go either way. You can win, you can lose. So when you have, I've been asking myself, you know, President Museveni forcefully declared the middle income against the protestation of World Bank. And we are now lower middle income to his declaration. I don't know whether World Bank ever confirmed. So if we are a middle income country, we need a mindset. Because a middle income country has characteristics. Two of them is active citizenry, people that you cannot bombard with organism. Two is rule of law. So if he's not ready to respect the constitution of court, the decision of court, if he can still go and write, this is a wrong decision, judges don't rule, then we are not middle income. And he needs to scrap off that false declaration of
Sarah,
his.
don't go into the symbolism. Substantively, the executive has made a public statement that they are going to implement the ruling of court. That is the most
Can we
important.
see the
That
implementation?
is the most important
Can we
element.
see the implementation?
Substantively.
We are concluding. I don't want us to go into another debate right now. We are running out of time. So, Dr.
Yeah, I want just to with all this good debate here, I want to go back to where I started from. This judgment surprised me, especially coming from the chair of Owinyi-Dolo, and I am very, very hopeful that it will change the thinking of so many other judgments that will come, because we had almost lost hope when you are taking a matter to the bench. You are not sure whether they are not going to give you a fanfare or a judgment of law. So we really feel that for a very long time, if I can remember, there are few judgments that have taken place and Ugandans jubilate. I used to tell people that, for example, in 2021, NRM won presidency and even parliamentary seats, but Kampala had to be under a military rule for about 3 months. Soldiers moving on the street so that nobody, you didn't see fanfare that I used to see when a president has won. I remember when Justice Katusi, I hope that's the name, Katusi, yes, ruled on the case between Uganda and Dr. Kizza Besigye, the celebration that was there. There have been other judgments. Then this judgment, I can tell you for a fact, I was chairing an exam. The students were doing their graduate presentations, and somebody announced this. We had to stop the meeting because everybody, even the students, were not willing to continue presenting without knowing what has happened. So we had to stop the meeting. No, this case here, this Supreme Court thing. So we had to stop the meeting and announce, then allow people to celebrate for about 10 minutes, then we resumed. Not that anybody in that room had a person in court, but people are just feeling bad that you see that bench of
the court martial.
The court martial. People were really feeling bad. You remember, you people forgot, when that court is called what? advisor,
Judge advocate.
judge advocate,
That guy, man.
said that there was a judgment, and the chairperson of the court did not know about the judgment,
he had
and he was
taken
now the one
control.
reminding
Chief
them,
Justice said
Yes.
he was an assessor.
and they didn't
Yeah,
have
of
the
course he
thing.
is like an assessor, but the man was all over the place.
So that court was really
I was
boring
there.
people.
Dr.
So for
Ojambo,
me,
I
I
need you to
for me, I
conclude.
feel that this is a success for this country. We need to celebrate it. How government implements it, that's their problem.
We shall call them to account.
Thank you. Thank you very much to you, my panelists, for this insightful discussion. Dr. Robert Ojambo, Dr. Sarah Bireete, Honourable George Odongo, and you, Mr. Joseph Ochieno. Thank you very much for being with us. And to you who is watching, thank you for being with us this far. My name is Judith Atim. This is the Citizens Chat Show. We've been talking about the challenges of implementing the Supreme Court ruling that it is unconstitutional to try civilians in the military courts. The Citizens Chat Show returns next week, same time. Do join us then, but also drop us a comment in the YouTube comment section. Bye for now.